Hi friends, good morning. Welcome to Annamaya IAS Academy. This is Dr. Harinath Reddy, Director of the Institute. See, from today onwards, we want to start a special edition on discussing the previous year's questions of GS paper 2 in the UPSC mains exam. As you all know, GS paper 2 in the UPSC mains exam includes 4 subjects: polity, governance, social justice and international relations. So we want to begin with Indian polity and constitution. So those questions which have come on Indian polity and constitution in the mains exam, that we will try to discuss every day one question. So how to write an answer for the question which has come in the past, what are the keywords in the question. So we'll try to explain it in a great detail. And then before we get started with the question for today, you all know that Indian polity is not only part of GS paper 2, it is also part of political science optional, PubEd optional and also law optional. So we will try to discuss all the questions on Indian polity which have come in GS paper 2, political science optional, PubEd optional, law optional and also in the Group 1 mains exam of Telangana and Andhra Pradesh. So why is it necessary? If you have a look at all the kinds of questions which have come on Indian polity from all these sources, your ability to understand and expect questions in the future will become much more. So if you can carefully analyze how questions have come in the past in all these optionals along with the GS2 and Group 1, so you can clearly make out how the UPSC is trying to ask questions. So if you are prepared in advance by working on these questions, you can easily predict what kind of questions can come. So you are so prepared for all kinds of questions so that you will have a lot of comfort and ease and answering any question which has come in the mains exam. But the addition is you need to read for the current affairs from the newspaper. Apart from the current affairs which are there in the newspapers, on all the topics of Indian polity, there is a question in the coming mains exam. You will be in a comfortable position answering it if you solve all the questions on Indian polity from all these sources: GS2, political science optional, PubEd optional, law optional and also Group 1 mains exam. So for today, I have taken one question which I felt very important, and this question is taken from optional, law optional. So in 2023, paper 1. See, polity is part of law optional in paper 1. So there was a question in 2023 in paper 1 of law optional. The question is something like this. The Constitution of India has provided for a clear-cut distinction between civil and political rights on one hand and economic and cultural rights on the other, with a distinct primacy given to civil and political rights. Explain. So to put it very simple, the question is about fundamental rights and the directive principles of state policy. So you all know that in the Constitution of India, Part 3 deals with the fundamental rights. Part 4 deals with the directive principles of state policy. So Part 3 deals with the civil and political rights. Part 4 deals with the social and economic rights. And you know that fundamental rights are justiciable. If any of the fundamental right is violated by the Indian state, you can go to Supreme Court and High Court to get that right enforced. That's the meaning of justiciability. But on the other hand, if you take directive principles of state policy, they are non-justiciable. For any reason, for a valid reason, if the Indian state is not in a position to enforce any of the directive principle of state policy, you cannot move Supreme Court and High Court to get that directive principle enforced. In other words, if fundamental rights are made justiciable under the Indian Constitution and the directive principles of state policy are non-justiciable, so it means primacy is given to civil and political rights. Primacy is given to fundamental rights. Primacy is not given to social and economic rights, part of directive principles of state policy. The question says that in India there is a distinction, there is a difference between civil and political rights which are part of fundamental rights, social and economic rights which are part of directive principles of state policy. For example, if you take the International Covenant on Civil and Political Rights, United Nations has come up with an international agreement on civil and political rights in 1966. In addition to that, the same United Nations also has come up with another international agreement on social, economic and cultural rights. So even at the global level, as per the international agreements made by UN, there is a distinction between civil and political rights on one hand, social, economic rights on the other hand. So this distinction is being followed even in India under the Indian Constitution. But you must remember carefully, see, in the question there is reference to cultural rights. The Constitution of India has provided for a clear-cut distinction between civil and political rights on one hand. Till this extent we don't have a problem. The later part, economic and cultural rights on the other. Here, cultural right we had a problem. Why? Under the Indian Constitution, you find the cultural rights both in the fundamental rights and also in the directive principles of state policy. But the question says there is a distinction between civil and political rights and economic and cultural rights. Here ideally the word should have been social rights. Economic and social rights, if this is the wording used, we have no problem. But in the question the wording used is economic and cultural rights. It creates a problem because cultural rights, they are part of part 3 and also part 4. Part 3 is fundamental rights. Part 4 is directive principles of state policy. If you take part 3, Article 29 and Article 30 both deal with the cultural and educational rights. Under the Indian Constitution in part 3 there is an article, Article 29. What does Article 29 says? Every section of citizens having a distinct language, script and culture of their own have a fundamental right to conserve the same. So Article 29, which is part of fundamental rights, deals with cultural rights. Similarly, Article 30 says religious and linguistic minorities have a fundamental right to establish and administer educational institutions of their choice. So Article 29 and 30 in part 3 deal with cultural rights. And you also find cultural rights in directive principles of state policy, part 4. You have Article 48A, Article 49, and there is one more article. Article 48 says, it is the duty of the state to protect and improve the natural environment. Protecting the natural environment is part of our culture from times immemorial. And if you take Article 49, Article 49 speaks about duty of the state to protect historical monuments and also places of artistic importance. They are also part of cultural heritage of India. In addition to this, there is one more directive principle of state policy which says promoting cottage industries. So promoting cottage industries is also part of the cultural history of India, where art handicrafts were part of cultural history. So it means in India, cultural rights, they are there both in fundamental rights and also in the directive principles of state policy. But you have to take this question as a civil and political rights on one hand, social and economic rights on the other hand. So in the question there is a problem with the wording. Cultural rights, they are there both in fundamental rights and directive principles. And how can you say that there is a distinction? But in the question, if it were to be civil and political, economic and social, then the question would have been a proper question. So then, what do you mean by civil right? See, civil rights are part of fundamental rights. Civil rights are those rights which protect the dignity, freedom, liberty and equality of individuals. So in general, civil rights are available for all the people in a particular country. For example, if you take in India, civil rights are available for both the citizens and the non-citizens. On the other hand, political rights are those rights which allow the citizens to participate in the political process. For example, if you want to get elected to the office of the president, vice president, if you want to get elected to another office of MLA and MP, if you want to become the judge of Supreme Court and High Court, only the citizens are allowed. These are called political rights. So political rights are those rights which allow a citizen to participate in the political process. The right to vote, to get elected to a public office. And on the other hand, civil rights are those which protect the rights, the individual right, the liberty, dignity of individuals. Then what are economic rights? Economic rights are those rights which deal with ownership of property like land reforms, then wages, employment and unemployment, etc. If you take social rights, access to health, access to education, access to benefits of social security. This is the distinction between civil, political, economic, social and cultural rights. Civil rights, I said, protecting the dignity, liberty of an individual. Political rights, which enable the citizen to participate in the political process, contesting to a public office, exercising the right to vote. Economic rights, so that is related to property, owning a property, having an adequate means of livelihood, having adequate living wage, and get to be employed. They are economic rights. Social rights, having access to nutrition, food security, quality health, quality education, they come under the definition of social rights. And then cultural rights are those rights which protect and promote the culture of different groups of people in a particular country. So after having done this one, the question says, in the Constitution of India, there is a distinction between civil and political rights on one hand, economic and cultural rights on the other hand. And the question says, primacy is given to civil and political rights. And if you can explain this point by taking examples. If you take Champakam Dorairajan case, Champakam Dorairajan case, in this case, the Supreme Court said that the fundamental rights are superior to directive principles of state policy. This is the stand taken by the Supreme Court of India. But later on, in cases like Keshavananda Bharati case, in Minerva Mills case, the Supreme Court said fundamental rights under directive principles of state policy, both are equally important. Giving primacy to one over the other is to disturb the balance in the Constitution of India. In other words, the Supreme Court said in Minerva Mills case that a balance between fundamental rights and the directive principles of state policy is a basic feature of the Indian Constitution. So the Supreme Court says that both are equally important. Fundamental rights are important, directive principles of state policy are also important. Fundamental rights, they focus on the rights of individuals. Directive principles of state policy, they focus on the rights of the community. Remember, the reason why directive principles of state policy are made non-justiciable is not because they are less important. In fact, B.N. Rao, the advisor to the Constituent Assembly, said it is the directive principles of state policy which are much more important than fundamental rights. But why fundamental rights are made justiciable? Why not directive principles of state policy are made non-justiciable? The reason is, if you want to implement the directive principles of state policy, then you need massive financial resources. If you want to improve public health, if you want to improve access to quality education, the Indian state needs a lot of money. So that's the reason why the framers of the Indian Constitution have given the freedom and flexibility to the Indian state when to implement the directive principles of state policy. For example, in India, elementary education is made a fundamental right through the 86th Amendment in 2002. It was implemented in 2009 through Right to Education Act 2009. So, in other words, the Indian state can implement the directive principles of state policy once it has got that administrative capacity and the financial resources available with it. So this is the reason why directive principles of state policy are made non-justiciable. But remember, once Parliament makes a law to implement the directive principles of state policy, then even these economic and social rights become enforceable. For example, land reform laws were made by several states after independence. It's about distributing the land among the landless people. Once a land reform law is made, then these economic and social rights are justiciable. You can go to court of law for enforcing that law. And again, take the policy of reservation. We have the policy of reservation for Dalits, tribals, OBCs, economically weaker sections, in government jobs, in government educational institutions. For this, Parliament has made a law, state legislatures have made a law. So once the Parliament makes a law, once the state legislatures make laws for enforcing any of the directive principles of state policy, then they become justiciable. So if these rights are not enforced, even there is a law in place, then you can go to court. But what the Constitution says, if the Parliament doesn't make any law, if the state legislatures doesn't make any law for enforcing any directive principle of state policy, you cannot go to a court of law. Once the Parliament makes a law, once the state legislature makes a law for implementing a directive principle of state policy, and if that law is not followed, and if that economic and social right is not implemented, you can go to a court of law. So here, if you remember, there is one important amendment, 25th Constitutional Amendment. It said, for implementing 39B and C versus Article 14, Article 19. So Article 39B and C, they deal with an egalitarian society. So distributing the material resources for the common good and preventing the concentration of wealth. 39B and C, they deal with preventing concentration of wealth and using the material resources for the benefit of every citizen in this country. So the 25th Amendment, which was done to the Indian Constitution, said, for implementing 39B and C, if Parliament or the state legislature makes any law, such laws can take away the fundamental rights guaranteed by Article 14 and Article 19 and also Article 31. In other words, the directive principles which are laid down in 39B and C were given precedence, primacy over the fundamental rights guaranteed by Article 14 and 19. So there were instances where the laws made by the Parliament and the state legislatures, when they have given primacy to some of the important directive principles of state policy over some of the fundamental rights, they were upheld by the Supreme Court. It is not that all the time fundamental rights have primacy over the directive principles of state policy. No. There are some directive principles of state policy, like under 39B and C, which have primacy over the fundamental rights guaranteed by Article 14 and Article 19. Because 39B and C, they aim at establishing an egalitarian society, an equal society. So in the very beginning, the Supreme Court said fundamental rights are more important, directive principles of state policy are less important. So primacy to fundamental rights over directive principles of state policy. But later on, the Supreme Court said both are equally important. So the balance between fundamental rights and directive principles of state policy is a basic feature of the Indian Constitution. But in practice, even today, if any of the fundamental right is not followed by the Indian state, you can go to the Supreme Court and High Court and you can have a remedy. But if any of the directive principles of state policy are not implemented, you cannot go to High Court or the Supreme Court. So even by today, we can say that there is a primacy to the fundamental rights over the directive principles of state policy. But remember, the Supreme Court, by using its power of interpretation, has expanded and included many of the social and economic rights. They were included under the fundamental rights. You know that there is one article, Article 21. Article 21 speaks about right to life and personal liberty. So this Article 21 was very liberally interpreted by the Indian Supreme Court, and within the ambit of Article 21, that is right to life, several other rights, economic rights, which are there in directive principles of state policy, they were made part of Article 21. For example, the Supreme Court said right to health, right to livelihood, right to education, they are also fundamental rights under Article 21. But right to health, right to education, they are there in the directive principles of state policy. So the Supreme Court, by creatively interpreting the provisions of the Indian Constitution, especially Part 3, it has borrowed the economic and social rights in Part 4, and they were read into Part 3 provisions. So this is the balancing act which the Supreme Court has done. So in Keshavananda Bharati case, in Minerva Mills case, the Supreme Court said both are equally important. Political and civil rights are important. Economic and social rights are also important. So there should be balance between these two. And the Supreme Court also says for implementing some of the directive principles of state policy, which are very important, some of the fundamental rights can be taken away. But in general, even today, fundamental rights have got primacy over the directive principles of state policy. So this is the answer for the question which has come in law optional in 2023. So that's it for today. So we'll come up with one more question in the next session. Thank you and all the best. We will provide you the answer for this question in the description box, and you can download this answer and you can do answer writing. Thank you and all the best.